Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 200. I'm delighted we've made it. I must say I thought at various points during the year it was unlikely we'd actually get to this point before the ending of my time at Mayer Brown. Certainly when I was writing various podcast episodes in the summer and late spring dealing with various iterations of the furlough guidance scheme, the thought of actually getting to episode 200, well, that was pretty daunting, and if it was going to be made up entirely of furlough guidance, frankly the chance of it happening was non-existent. Anyway, we have what I would loosely call my top 5 key points for employment lawyers, following on from episode 199, which I recorded yesterday. It's probably worth listening to that episode before you do this one, simply because of the context, which I think I have to set around these 10 key points to being an employment lawyer. Actually, I see that's been mistyped as 10 key points to being an important lawyer. Okay, maybe that was a Freudian slip. Anyway, top 5. Point number 5. My 5th point. Always keep calm and keep a clear head. That sounds dangerous, like that mug about keep calm and carry on. And it is a bit of a truism. But it's remarkably difficult to do. Clients often expect us to give answers instantly. Sometimes we put pressure on ourselves to give answers instantly when it's not necessary. And I talked in the previous podcast about the dangers of settlements being concluded against that background, a background of speed and urgency. Some lawyers, the lawyers that I admire most, are the ones who are able to keep a clear head while they're operating, often at top speed. They can somehow filter out the grief and stress in a situation so they can see clearly what is happening and what needs to be done. They're not distracted. I had an excellent example of that about 6 or 7 years ago on a highly contentious matter. Our clients had recruited a number of individuals from a competitor. The other side had gone for an injunction. We'd filed affidavits in response affirming that the recruitment had been entirely legitimate. There had been no inside helping hand with the competitor. The interim injunction hearing went very badly, and so we decided to go to the Court of Appeal. Mid-afternoon, the day before we're due in the Court of Appeal, it becomes apparent that there are certain significant discrepancies, shall we say, in our client's affidavit evidence when compared to documentation that was only just being provided to us. Initial inquiries revealed there was no clear answer to these discrepancies, and so now we were very unclear about what the truthful, factual situation was, compounded by the fact that some of what we had been told now looked to be clearly wrong and had come from relatively senior sources on oath within the business run by our client. In a textbook example of how to deal with this situation, the barrister concerned did not waste any time remonstrating with us as to how the hell we find ourselves in this position. The barrister was very clear about what we could and could not say to the Court of Appeal from a professional perspective, given the uncertainties about the factual case. Equally, the most senior individuals in the client, who were relatively untainted by what had been going on, were able to work with us and give instructions that meant we were able to fight the case in the Court of Appeal the following day on the remaining grounds open to us, although of course our prospects had been materially damaged. Basically, the teamwork and cool heads meant we were still fighting, we'd been functioning, we could provide advice on the case and how we were going to maintain the appeal, and ultimately how we were going to resolve matters. In a different world, if we'd spent time battling with counsel the night before the Court of Appeal hearing, we would never have time or the ability to work out a plan of action to ensure that the client could put its best foot forward, both the next day in the Court of Appeal and then thereafter in relation to any settlement discussions. So, point number 4. Never be afraid to ask the other side what they're looking for their client. One of the things that strike me is that there are particular lawyers who will tell you, and probably earnestly, genuinely believe, that disputes are best resolved after a period of time, after a period of warfare. Wear the other side down, tie them in knots, run them ragged, and only then look to settle a case. The fact that the corollary to that is that the lawyer concerned earns a tidy sum in fees for doing said running, raggetting, tying down, etc., is probably entirely irrelevant. But the truth of it is that most matters are best dealt with by agreement, and an agreement reached early is often a lot easier to reach than an agreement reached later. Commercial deals and litigation have that in common. I regularly, with client approval, ring the other side as soon as we are instructed on a matter which is in any way contentious or troublesome. I often ring without any prior warning to introduce myself to the lawyer on the other side. I tend to say to him or her, under cover of a WP conversation, that I believe effective communication between lawyers resolves many matters, and on that basis I ask whether they're able to just talk me through the key points in their case or their claim or whatever it is, and what are they looking for? What are they hoping to get out of this? I make it clear I don't have all the facts at that stage. I cannot promise that we will agree with them, but I do promise that I will listen to them carefully and respectfully, and equally, if when I go back and take instructions we disagree with what's been put forward, having taken instructions I'll come back and share with them our corresponding view of the case in turn and whether we think a settlement is feasible. It's amazing what you learn from that phone call. There are lawyers who are completely comfortable with taking a call out of the blue from me. They'll speak to me about what they think the case is, what the great points are, what that client is looking for. They've thought it all through. They're a pleasure to deal with. You also have lawyers who refuse to speak to you at all, which seems like a very odd decision to take. Then there are the lawyers who confess quite freely they don't really know what their client is looking for out of the claim or the litigation. And they seem to be the strangest group of all. How can you start litigation without having a clear idea of what you want to achieve for your client? In any event, the point of the debate is that in almost all cases, in fact, I'll go further, in all cases, you learn something during the course of the phone call. And it's much more often than not, it's the start of the process of building rapport with the other side, listening to what they say, treating them with respect, and as often as not, it provides the necessary first step that ultimately gets matters to an agreed solution. So I think that is a clear and important point, and one that it almost always pays dividends. It really does. I had a really good example of this the other year. Slightly different, maybe say really good examples overstating, but it's on the same point. I was dealing with a case where there was a litigant in person on the other side. I was acting as the front person for a case that was being conducted by a junior lawyer in the team, and it was felt more appropriate to have communications to the claimant routed via me, so that I got the stroppy responses rather than going directly to the junior lawyer. The litigant in person was clearly frustrated, wanted vast sums of money, so there was never going to be an easy settlement. And she was frustrated that she'd found herself in litigation, and understandably she lashed out, and I got a fair amount of this. She wrote a series of pretty confrontational emails to me during the progress of the tribunal case. And I got one email in the early hours of the morning which she'd written, which in a particularly aggressive communication, accusing me of various things and generally being very hostile and unpleasant. I put the email to one side, metaphorically speaking, because I wanted to think about what I was going to do by way of response that wasn't going to make things worse. And before I'd responded, she sent me a follow-up email later on that day, in which she apologised profusely for the email that she'd sent overnight, and that she explained that she was struggling because of litigation. She acknowledged that she had vented, and she wanted me to know that she regretted what she had written, and she would appreciate it if we too would delete the offending email from our systems. So I went back to her to say I fully understood her position. If she was finding that litigation was a frustrating process, that is undoubtedly the case, particularly if you're not doing it as your day job. I also said that I appreciated her apology, because I did, and in the circumstances there was no question of us referencing the abusive email she'd sent the night before, and I could confirm that we wouldn't refer either to her email at all in front of any tribunal. I then had a very gracious thank you from her. The case settled about a month later, and I had an email at the very end of it saying that she thought that had she and I met in different circumstances, we would have got along very well. I'm really proud of that outcome. It suited my clients to get to a deal. It was a deal on terms that suited my clients, but equally, by not allowing a contentious email to fire things up, I was benefiting my client's interests. Also, by being sympathetic and humane towards a litigant in person, she was able to find a way to a position where she was happy to settle a case, and she was gracious enough to acknowledge that she'd had some help in getting there. So, overall, I thought that was a pretty good outcome for all concerned. Point number 3. Okay, we're into the top 3. This is a tip that I think we would all do well to bear in mind. I'm going to illustrate it by telling you about a case I did about 15 years ago, which is in the public domain, so I'm not telling anything that isn't already known. We acted for the Football Association during the FA and Faria Alam three-ring circus. As I say, we were acting for the Football Association. The background was that newspaper reports started circulating with suggestions that the then England football manager, Sven-Göran Eriksson, was having a relationship with Faria Alam. Sven's reply, when he was asked this, was somewhat opaque. But the FA understood that he was denying the relationship. Faria was denying the relationship, and so the FA started a vigorous campaign to defend their reputations. It then came out that there was a relationship between them, but that also Faria had apparently been having a relationship with another member of the FA board at the same time. So a crisis board meeting was scheduled for one Friday. 4 days beforehand, the lawyers acting for the FA realised they had a conflict and they had to drop out. And so completely out of the blue, I was called at work and asked if I could go to the FA literally immediately. Now, we'd never acted for them before, so I didn't know anyone there. 4 days later, we're advising the board on what is to happen. It's the biggest story in the UK. It's got a lot of coverage worldwide. That then rolls forward into a tribunal hearing about 12 months later, where we successfully defend the Football Association on all claims by Faria Alam. It's undoubtedly a great win for the client. It was a high point in my career. But the point I would make is that although I am fiercely proud of us delivering a great result for the client, it all came down to luck. In your career, there can be good days, there can be bad days. And it was luck in that the existing lawyers got themselves conflicted. It was luck that I'd done a job a few months before that as a complete favour to a chief executive of a Division 1 football team. So when the FA needed a new lawyer, he put in a good word for me. It was luck I was even in the office that day because I'd stayed behind when my family had gone on holiday because I had too much work to do. It was lunchtime when the call came in, and it was luck that I picked it up rather than let it ring through to my secretary, who might, for all I know, have been out at lunch herself. So all those things had to fall into place for us to get that result for the client. And I think it's important to remember, we're not omnipotent. Things don't happen because lawyers decree them. And if you have a really good win, sometimes I think it's good to remember that maybe sometimes those were the cards that you were dealt, and be a bit humble. Conversely, when you suffer a crushing loss, sometimes those too were the cards that you were dealt, and maybe that'll help you deal with it. I think if we can remember that at all times, those are the cards that we're dealt, and that some of this is just luck, we'll be more resilient and better grounded, and less self-deluding about the influence that we can wield to get the necessarily right outcome from our client. After all, I don't think I could finish a podcast without quoting at least once from Rudyard Kipling, who made the point about if you can meet with triumph and disaster and treat those two impostors just the same. I think there's an awful lot in that. So, on to point number 2, one off the top spot. This relates back to a conversation I had a few years back, and I'd be really interested if anyone listening to the podcast has a similar story to tell. But the genesis was a conversation amongst a group of lawyers about the best legal advice you have ever seen given to a client. What were the circumstances? What was the advice? That in turn led into what amounted to good legal advice. What was the discussion about what amounted to good legal advice? But for my money, there was one clear winner from that conversation. It was a very diverse group, different firms, different areas of the law. And one of the lawyers there came from a libel firm. He was now a relatively senior lawyer, but as a trainee solicitor, he said he'd witnessed the best advice he'd ever seen being given to a client by the then senior partner of this particular law firm. Background to this is that a very, very well-known rock band from the 1960s was in some difficulties by the mid-1980s. Its CDs and records were not selling in any quantities. They'd announced a tour which was not selling out. Worse still, it was being widely suggested that the particular lead singer of this band had AIDS. Now, I don't think there was any truth in that story whatsoever, but it was undoubtedly a rumour that was circulating widely, and it had been referenced in a music magazine published in the UK. And bear in mind that at this point, the mere suggestion that an individual had AIDS was carried a significant social stigma. Representatives from the band came to see the senior partner, seeking his advice on bringing a claim for libel against the relevant magazine. The client outlined the problem, the difficult circumstances the band found itself in, why there was a need to protect his reputation at all costs, and asked for advice on litigation strategy. Well, having heard what the client had to say, the senior partner, at the end of the meeting, advised them to take a very different approach. He suggested that instead of threatening or indeed starting proceedings for libel, instead the band would merely put out a short press release. This would simply say that the name of band, can neither confirm nor deny that the name of lead singer was suffering with AIDS. Full stop. End of press release. You can imagine the reaction when he comes up with that advice. But the person telling us about this conversation explained. They went along with it. They put out the press release. The rumour mill goes into overdrive. Everyone assumes, therefore, that the said lead singer does have AIDS. Therefore, the tour sells out instantly because people assume it could be the last tour. The CD that was being promoted by the tour becomes a massive hit. And, of course, the lead singer's fitness levels quickly demonstrated there was nothing in the rumour that had been circulated. And it turns their fortunes around. And I've always loved that story because it's brilliant advice. It's insightful. It's legal advice that was hugely commercial based on knowledge of the client and the market and a willingness to look at problems from a different angle when coming to a solution. So, yeah, I'm sure we've all got examples, stories where we've seen that done. So, as I say, I'd be interested in any of those that you have to share. Okay. Last point, top point. What's my top tip? Well, I'm sure it won't surprise you after this podcast. You got this far in the podcast. It's another story. And I think it's the most valuable lesson I was taught about being a lawyer. It came to me from the former head of the employment team here at Mayer Brown, Julian Roskill. He and I were acting on a case. When I joined the predecessor firm to Mayer Brown, it was a firm called Rowe & Moore. Now, the case in concern had been running for about a year, and it ran for another 4 or 5 years. We were acting for a senior executive who'd been sacked in, well, let's say highly contentious circumstances, after he delivered stellar performance for his employer. The problem was he was given a very, very lucrative package to turn the company around in 5 years, did it in 18 months, wrecked his health, and was then sacked. So, for a number of years we battled to get the case to court, and then with about 6 months to go, the tide turned, the pressure really mounted on the other side, who could not substantiate the justification for the summary dismissal, and as a result the case settled on extremely favourable terms. But my lesson was that I remember vividly at one point being on a conference call with Julian, and we got the barristers on, and we were discussing a particular point, and I advocated taking as aggressive approach as possible. And when I was asked why we should do that, I said it was about time the other side started to pay for what they'd done to Rowe & Moore. Now Julian cut right across me on the call, leaving me in no uncertain terms that this was not Rowe & Moore's case. It was our client's case. And unless it benefited our client to take the point, we would not take the point at all. And it's always been a guiding principle in advising clients for me ever since, and a point I've made to lawyers in the employment team here again and again. It's never the case that we win or lose. Our client wins or loses, and it's always our client's case. The minute we start to identify with the case as being our case, we lose our judgment and the ability to be professional advisors, and we lose the essential ability to listen to our clients to get them to the point where they want to get to, not the point we think they should get to. So, there we go. Top 10 points. Keys to being an employment lawyer. So, it only remains for me to say thank you very much for listening to this episode. And if you've listened to all 200 others, you certainly deserve a medal. I would also very much like to thank the BD and IT teams who supported me in the development and creation of the podcast, and then putting out episodes roughly every 2 weeks for the last 8 years. That's definitely been going above and beyond. I'd also like to thank those who've been guests on the podcast over the years, some of you more than once. It's been great fun. I learned that interviewing people on a podcast is a different skill set from doing a podcast on your own. I'd like to thank everyone within the Mayer Brown team who's appeared on the podcast. As I say, Chris Fisher is going to take the podcast forward, and given the support I've had from BD and from the IT people, I know he is going to be in very safe hands with them taking the podcast forward. So, in time-honoured fashion, I'd say thank you very much for listening. I hope everyone stays safe and out of harm's way. Oh, and you have all the best in 2021. And it only remains me to say that no one involved, I hope, in making the podcast at any point in the last 8 years was ever mistreated or harmed in any way. Take care, everyone.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayerbrown.com. Thank you for listening to the podcast.